Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome to our second in our series of podcasts looking at regional issues impacting upon arbitration in the Baltic States. My name is Ian Meredith, a partner in K&L Gates London office, and my guests today from Ellex Valiunas are Vilija Vaitkute Pavan, Tadas Varapnickas, and finally I'm joined by Simona Budreikaitė. If you've not yet had a chance to listen to part one on this topic, you can find a link to it in the description for this episode. In the first episode, we look at more generic issues impacting across the region. And in this, our second part, we're going to look at some more specific aspects. Before we get started, I'd just like to note that this podcast series is limited in scope as appropriate for a general audience and the applicable time constraints. The information in this podcast series is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case, and all speakers appear in their personal capacities, and any opinions or views offered are those of the relevant speaker alone and do not necessarily reflect the opinions or views of K&L Gates LLP, Ellex Valiunas, or any other entity or individual. Vilija, could you give us a summary of the position as things stand at the moment in relation to investment arbitration across the Baltics?
Yes, thank you, Ian. With pleasure, because I'm working really with and I'm currently working with a number of investment arbitration cases involving our region. And just maybe to start with some kind of statistics to give a general understanding, about the scope of investment arbitrations in our region. So since our independent times, so a bit more than 30 years, in total, Lithuania, Latvia, and Estonia as respondents had 23 investment arbitration cases, whereas the claimants from those host states, they initiated 16 investment arbitration cases against other foreign countries. And in more particular, Lithuania as respondent was in 9 investment arbitration cases. In A3 investment cases, Estonia 5 cases, Latvia 10 cases. Where the claimants from Lithuania in investment arbitration were again 8 cases, Latvia 5 cases, and Estonia 3 cases. So, but nevertheless, 23 as respondent and 60 as the claimants from host states, there are quite significant number of cases. A lot of those, in fact, were involving Russian or Belarusian entities. And in this regard, it's important to understand, that what is the situation with the BATs among our Baltic states and Russia and Belarus. In that regard, I should stress out that Lithuania at the moment is terminating BATs both with Russia and Belarus. Latvia and Estonia have not had any investment treaty with Russia. And in relation to Belarus, Latvia already initiated termination process 2022, and Estonia had one with Belarus, but it did not come into the force. So of course, all of those terminating contracts, they had sunset clauses, but in quite a few years, the investments from each of those countries, they will not be protected by bilateral investment treaties. That is probably important to understand that when somebody is structuring its investments in the corresponding countries. So, but in general, we also anticipate several investment cases against Baltic countries involving implementation of sanctions as well as the national security related issue. And it's already in the public domain that currently Lithuania has one investment arbitration case involving national security as well as sanctions issues with the Belarusian entity. Yet another case most likely also could be initiated in relation to implementation of sanctions. So investment disputes are visible in Lithuania, and in majority of those cases, local councils, they work together with international councils, with their foreign colleagues.
Thank you very much. I'm continuing to, I guess, look at the relevance of sanctions and outside the area of investment arbitration. Could you just touch upon pending cases and trends that might have a wider global impact? And I'm thinking here about the ECJ referral that I know you're close to.
Yes, thank you, Ian. Indeed, as I said, so the geopolitical situation and geographical situation of the Baltic countries, they inevitably encompass quite substantial number of sanction-related disputes. In that terms, we should understand that all our countries, Lithuania, Latvia, Estonia, they are part of EU. It means that they have to comply with the sanctions imposed by EU. And since the beginning of the Russian invasion in Ukraine, the number of EU sanctions, there are really a number of sanction packages, and not all wording of them are quite clear. In that terms, when Lithuania, Latvia, and Estonian companies, they are implementing and applying sanctions, it might be that dispute arise between, for example, client of the bank and the client, where the bank freezed accounts as a result of application of sanctions. And the local courts are referring appropriate questions in relation to application and interpretation of appropriate EU regulation in relation to sanctions related to Russia and Belarus to ECJ courts. And Lithuania is quite active in that regard. And so it's like a pioneering when Lithuanian court prefers for preliminary ruling. That preliminary ruling will have impact for application of sanctions for all EU countries. So in that terms, I think Lithuania is quite pioneering because insofar there are quite a few referrals to ECJ for preliminary rulings from other European countries.
Thank you very much. And just to conclude on this issue, Simona, could I ask you just to touch upon some Lithuanian court rulings in the area of recognition and enforcement of arbitral awards?
Yes, so I think the area on recognition and enforcement could be divided also on some general remarks and then to some topical and more interesting issues, for example, those that are related to sanctioned entities or otherwise a contract affected by the sanctions. But if starting with the general remarks on recognition and enforcement, the first thing I guess to say is that, of course, all three Baltic states are parties to the New York Convention and apply it when dealing with the recognition and enforcement matters of foreign arbitral awards. And although the public policy exception remains one of the most frequently involved grounds in local court proceedings, the chances of success, at least statistically, in relying on this ground are very low in local courts. Talking from the procedural point of view, for example, in Lithuania, any requests for recognition and enforcement of foreign arbitral awards are not subject to any court fees. And while there is a local language requirement for the proceedings, there's, for example, no need to have either a physical presence on Lithuania, and all documents can be served electronically, which can also help and aid foreign parties. Also, none of the three Baltic states requires, for example, the respondent to appoint a local counsel in the local jurisdiction. And the proceedings, I would say, are quite fast. They are predominantly held in written form and usually take less or about 6 months. And also the courts in both Lithuania and Estonia frequently entertain requests for example, application of provisional measures to secure future enforcement, may also order the award debtor to provide suitable securities in recognition and enforcement cases. Now, going to some topical issues, and given the current geopolitical climate, in the recent years, the Baltic state courts are sought more and more with requests to recognize and enforce the awards in disputes which are in some or other way connected to international sanctions. And the general stance of the courts is that if a foreign arbitral award is issued in favor of a either directly or indirectly sanctioned party, or if the arbitral award which enforcement is otherwise forbidden due to applicable sectorial sanctions, the courts rule that such an award could not be recognized and enforced either in Lithuania, Latvia, or in Estonia, and cite the public policy exception in the New York Convention. But by contrast, for example, Lithuanian courts have also dealt and ruled on another issue, namely that if the nexus between a party which is requesting recognition and the EU sanctions is solely the fact that a party is from a jurisdiction subject to European Union sanctions, but that same party is not itself sanctioned, such nexus does not constitute a ground to establish a violation of public policy, and such awards can indeed be recognized and enforced in Lithuania. And this is actually in contrast with, for example, Russian courts, as recently we saw some news reports about the Russian Supreme Court in summer of 2024, hinting that foreign arbitral awards in Russia might not be recognized and enforced just because the party to the proceedings or the proceedings themselves were held in the so-called unfriendly jurisdictions. So if such practice from the Russian court continues, I think it will be very interesting to see whether the Lithuanian courts will also take a different stance on this issue in proceedings involving, for example, Russian counterparties, given the principle of reciprocity in international law.
Thank you very much, everybody. I think that was really helpful and interesting through both podcasts. I just wanted to express my thanks to you for participating and sharing your thoughts on these interesting and topical subjects. Thank you very much indeed.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.